Hey there, welcome to Help Solve the Case. We are continuing our review of the Pamela Smart Habeas petition, talking about all kinds of interesting things in why she and her defense feel that she should get a new trial. We talked about jurisdiction, we talked about transcripts, all kinds of things, and I think we're about to get into the nitty-gritty about some of the interesting stuff about the psychology behind the transcripts and the garbled audio, which, as I mentioned in the video previous, for me, I feel could have wide implications, and for you too, and for many defendants, could have wide implications across the criminal justice system. So thank you for being here. I love that you're here. Your being here helps me support my efforts to provide free case assistance to law enforcement agencies who have lost a hero or heroine in the line of duty, and just continue doing this great work. So I really appreciate your support of that. We have over 15,000 unidentified human remains cases across the United States and hundreds of thousands of unsolved cases. I was just looking in the local jurisdiction here where I live, and I believe over the past 10 years, there's about 1,000 sexual assault cases with like a 10% clearance rate. Horrible, horrible, horrible. I have the resources. I believe I can take care of it. So couldn't do it without you. Thank you, thank you, thank you. So let's continue with Pamela Smart's request for habeas. And this is not the first time, but they're coming at it again. And they did have their hearing. We've got some jurisdiction issues because she's being housed in New York, but the case is actually from New Hampshire. And they did make their oral argument in New Hampshire not too long ago, and we're waiting for the results. But the things that they're raising here can apply in other cases. The precedents they're citing and different things can apply in other cases, and that's why it is so important. They're talking about here about adequately novel claims may be raised, and what they mean by novel is new claims. The Supreme Court of the United States has also recognized the ability to raise novel claims in a habeas petition if it is reasonable that trial counsel did not raise a claim due to the claim being too novel at the time of trial, and the failure to raise the claim did not fall below professional norms of practice. So what they're talking about is ineffectiveness of counsel and trying to, sounds like they're dancing around it a little bit, that there might have been something new, but they weren't sure how good it was. So the original trial counsel kind of made the right decision because it didn't fall below the professional norms of practice. It says such cause can overcome default. What they're talking about by default here is meaning the default is the limits that you cannot claim stuff anymore. Okay, that there's a limit. But they're saying that these adequately novel claims can overcome the default. And it says the question becomes, was the claim, quote, sufficiently novel at the time of the appeal from a conviction to excuse an attorney's failure to raise it at the time, end quote. Meaning that was it novel enough, new enough that it could, the bad behavior by the attorney, not bad behavior, the excusable behavior by the attorney allowed for acceptance that they didn't raise it at the time. The Supreme Court of the United States has held that, quote, where a constitutional claim is so novel that its legal basis is not reasonably available to counsel, a defendant has cause for his failure to raise the claim in accordance with applicable state procedures, end quote. And that sounds like a huge statement. Who makes the determination that it's very novel? Because one defense attorney could say, well, we're going to use that. We need to use that. We need to throw everything and the kitchen sink in. And the other attorney might say, that's too new. I don't know if I can trust it. In fact, in this case, in this habeas petition, the defense is raising the novel issue of this paper about the transcript. This paper, the investigation that the authors did, I went to look for it. It's in the prior video. this precedent that they're basing it on, or this scientific study, is not even, it's in peer review. It's not even published. So it is not available. It's in peer review from what I understand. So that's pretty novel, right? It's not even published yet, but they heard about it or they went looking for it. So that's like, how novel can it get when it's not even published? And they're throwing it in. So should it have been thrown in? Do you get what I'm saying here? Like, who decides? I'm asking all these questions lately. Who decides what? Who decides how novel? And again, when you get into court, they're going to compare. Well, in this case, you did this, and in this case, you did that. And so here they're saying that if it was too novel, even though it was available, it's okay. But here, they're raising their own novel, super novel thing. Go figure. It says, in Reed v. Ross, Ross was convicted of first-degree murder and sentenced to life imprisonment. He had claimed lack of malice and self-defense, and in accordance with well-settled North Carolina law, the trial judge instructed the jury that Ross had the burden of proving each of these defenses. Ross, isn't that interesting? Aren't you innocent until proven guilty? Ross did not challenge the constitutionality of this instruction. However, this instruction was later found violative of due process. The court held that, quote, counsel's failure to raise a claim for which there was no reasonable basis in existing law does not seriously implicate any of the concerns that might otherwise require deference to a state's procedural bar, just as it is reasonable to assume that a competent lawyer will fail to perceive the possibility of raising such a claim. It is also reasonable to assume that a court will similarly fail to appreciate the claim, end quote. Again, going back to who's going to make the decision, because whose interpretation is it? They're saying one people are going to interpret thing one way, the other are going to interpret it another way. The Supreme Court concluded that, quote, Ross had cause for failing to raise the issue at the time, end quote, acknowledging a retroactive constitutional principle that had not been previously recognized. Novel. Quote, if we were to hold that the novelty of a constitutional question does not give rise to cause for counsel's failure to raise it, we might actually disrupt state court proceedings by encouraging defense counsel to include any and all remotely plausible constitutional claims that could someday gain recognition, end quote. Everything plus the kitchen sink. So, they say Ms. Smart recognizes a potential inconsistency in both arguing counsel as ineffective for not making an argument. Here, just what I said, that may also be considered adequately novel. In such instance, Ms. Smart first asserts counsel was ineffective. However, if the court, upon review of this petition, determines an identified error to not have been violative of professional norms at the time of trial, Ms. Smart asserts in the alternative that such argument must be viewed as novel. They're saying whichever way you need to do it, go for it. A claim delayed by good faith may be reviewed. When a defendant does not discover evidence or is not made aware of the materiality of claims in time to raise the claim in an earlier filing, or otherwise does not intentionally delay the filing of a claim for the purpose of prejudice, a defendant lacks the ability to raise the issue in a prior filing. Moreover, where there is a lack of bad faith, and when filing in good faith, and a defendant is serving the severe penalty of life in prison without the possibility of parole, it is in the interest of justice to review any prudently brought and meritorious claims. And we've heard this about the interest of justice and getting past this default of you get no more appeals. They talk about the standard recognized in Humphrey v. Cunningham. In that case, the petitioner argued in his habeas petition that his counsel should have filed a motion to dismiss on speedy trial grounds. Petitioner's trial was delayed due to the state's failure to provide a purportedly exculpatory photo array. And let me stop there, because this is important. As I mentioned, all of these cases have impact on other cases, and we can talk about cases currently in the system and stuff like that. So, speedy trial. You have a right to a speedy trial as a defendant. But let me tell you, if you don't have all your discovery, you can't have a speedy trial. And there's a deadline for a speedy trial. And I see this a lot. And what they're saying here is his counsel, in this case, Humphrey B. Cunningham, his counsel should have filed a motion to dismiss on speedy trial grounds that they didn't meet the speedy trial requirement. But the trial was delayed due to the state's failure to provide a purportedly exculpatory photo array. Yes. So how do you maintain speedy trial rights within a timeline deadline and say that you're going to go to trial? But the state still hasn't given you evidence that they're required to give you that's exculpatory, and they're required to give it to you because it's exculpatory. They're required to give it to you because it was used in the case, and it's exculpatory. But you have a deadline over here. So what do? That's a decision that's made a lot. I've seen cases where they drag their feet 5 years. We're still asking for discovery in a criminal trial. Yes. Yes. During habeas proceedings, again, we're talking about Humphrey v. Cunningham, the state argued that the petitioner could not argue in his habeas petition prejudice due to the loss of the photographic array because the, quote, petitioner presented the issue of the loss of the photographic array in the notice of appeal filed during his direct appeal, end quote. The court disagreed with the state's characterization of the issues, specifying that the, quote, issue previously appealed by the petitioner, as stated in the notice of appeal, was whether the court erred by denying the oral motion to dismiss for failure to preserve potentially exculpatory evidence, i.e., the first photographic array, end quote. The court, apparently, in that case, Humphrey v. Cunningham, filed a motion to dismiss under speedy trial, that the speedy trial rights were being violated, or that it was under Brady, that they didn't get it, and it was denied. So it sounds like they lost the speedy trial rights. Not exactly sure, but this is important. And now they're talking about, because when you have an appeal, you need new information. You can't argue stuff that's already been argued before and has failed. But they're saying here that the issue had been waived by not properly briefing it on appeal. But the court said that the prior direct appeal, quote, never addressed the issue of prejudice to the petitioner caused by the loss of the photographic array. The issue was not therefore fully litigated on appeal. So that sounds like they did bring it up, but they didn't argue. Let me give an example. We were reading Carmelo Anthony's, I was reading that huge motion for new trial. And it was going through what it seemed to be over and over again, the same thing said different ways, right? It was a bit tedious to read. I'm sure it was a bit tedious to listen to. But that sounds like what they're saying here, that even though they brought it up, they didn't fully flesh it out. So in the Carmelo Anthony case, is that why ba-boom, 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 they're saying it every which way? They're using all kinds of different language to make sure that it was fully litigated, fully argued, fully hashed out, fully enunciated, fully articulated. Good points. That's what's telling you. Good points here. The Humphrey court held that petitioner, quote, arguing that he was denied his right to a speedy trial, end quote, and that such delay prejudiced his defense did, quote, not appear to be circumventing the appellate process, end quote. As there was no indication of, quote, procedural abuse by the petitioner, end quote, the court held it appropriate to consider the issue as part of the petitioner's ineffectiveness assistance of counsel. In the instant case, when they say instant case, they're talking about the one we're talking about now. The filing of this petition was delayed for reasons wholly outside of Ms. Smart's control. Specifically, Ms. Smart was unable to previously raise in full the issue of the state's use of misleading and prejudicial transcripts, because prior to the 2025 Davidson study, that's the one we're talking about, Ms. Smart lacked the requisite empirical evidence on which to base her claim. So she didn't have the facts. Ms. Smart acted without delay in filing this petition as soon as she received the results of the Davidson study and was able to support her claim, filing even before the study has been officially published. Talk about novel, remember? A claim against an illegal sentence is not subject to default, and default again means the you ain't filing no more. An illegal sentence may be addressed in a petition for habeas corpus, as New Hampshire has unmistakably stated, quote, a petitioner can collaterally challenge an illegal sentence, end quote. Ms. Smart argues she was given an illegal sentence when the trial court imposed a mandatory sentence of life without the possibility for parole to a crime that did not carry a mandatory sentence. That sounds like a pretty big boo-boo, doesn't it? Failure to exert discretion constitutes an abuse of discretion. Now we're going to get into the meat of this, the stuff about the transcripts here. They're talking about their argument. The state's use of inaccurate and misleading transcripts at Ms. Smart's trial violated Ms. Smart's due process rights, and her counsel's failure to object to the transcripts deprived Ms. Smart of her right to the effective assistance of counsel. The state manufactured evidence that imposed a cognitive bias against Ms. Smart. Specifically, an unknown member of the Attorney General's office listened to low-quality audio of body-wire conversations of Ms. Smart and then created inaccurate and prejudicial transcripts of what the state wanted the jury to believe was said in those conversations. So, somebody from the Attorney General's office and created transcripts. Now, when I worked as a paralegal for the public defender's office, way back in the dinosaur days, I transcribed stuff. So I'm wondering, when they say Attorney General's office, I'm thinking investigator. Was the investigator doing this? This is in the 90s, right? Did they have a transcriptionist on hand, or did they outsource it? Because as I mentioned in the previous video, I have cases where they outsource the transcript and the transcript is wrong. I'm listening to it and it's wrong. It is missing complete sentences. It says unintelligible all the time, and it was an absolute mess, and I could hear it. Now, somebody from the Attorney General's office, is that a neutral third party? We don't know. But were they transcribing it in the prosecution perspective, that their vocabulary was more conducive? That's not the right word. The words that popped into their head were more prosecution type words, sounds like conviction instead of collaboration, just as an example, right? I don't know, just what I'm thinking about in reading this. The state then introduced the transcripts to the jury the first time the jury heard the low-quality audio of the body-wire conversations. The jury did not have a chance to listen to the tapes without the transcripts in front of them. This created an expectation-induced bias. It was error for the state to present these inaccurate transcripts, as this amounted to the state arguing facts not in evidence, arguing improper opinion testimony, and ultimately denying the jury's ability to remain impartial. I'm just thinking, I wonder if that audio is available, and if we could listen to it, we could play it, and then everybody could say what they think without the transcript. And then we could look at the transcript and we could do our own evaluation. Maybe if not this case, we could do it on another case. It was also error by the trial counsel to fail to object to the transcripts as inadmissible and overly prejudicial. Did they even do a line by line reading, listening. I do that. Did they do that? We don't know. The presentation of the transcripts to the jury, including through deliberations, denied Ms. Smart a fair adversarial testing process and rendered her conviction unreliable. The court process is called adversarial, and we talk about adversarial, the right to confront witnesses. The prejudice to Ms. Smart is not mere speculation. Prejudice is supported by scientific studies generally and by a study examining Ms. Smart's case specifically. So, did they pay for this study? Isn't that interesting? Let's see. Hopefully, we'll learn more. Scientific consensus holds that transcription of degraded audio imposes a curse of knowledge, these words, in that transcripts cause a person to hear what they are told they will hear. In other words, transcripts are powerful instruments of expectation-induced biases. That's a new term for me. In the interpretation of auditory evidence. Now, I will tell you, people learn 3 ways: auditorily, visually, and kinesthetically, by doing, by touching, whatever. So that's also something to consider. When you're training, when you're presenting, you should be speaking, you should be showing, and sometimes, if you can, giving people something to do. I take in better by looking. That's why I like showing these things to you, whatever. I am a visual person. Hearing something doesn't cut it for me, okay? Because I take pictures. I visualize and paint a picture. For instance, if you're going to give me directions, I want to see it written down on a piece of paper. You know, when someone says, go left at the first stop sign and then 2 lefts and 2, I'm like, bleh, all right? But if you write it down and I see then that piece of paper in my mind as I'm navigating, I can do it. But hearing it, not as good as visually. That's why writing my reports and whatever as a police officer, I play the movie in my head. And you can tell something off the beaten track here. You can tell by how people speak which way they are. Okay, let me get back to this. Expectation-induced biases in the interpretation of auditory evidence. So is it saying, just popped in my head, because they're seeing the word, right? Maybe they're visual. Maybe most people are visual. If they're seeing the word, it then converts what they're hearing, or one over the other. So if you were an auditory person and not a visual person, would it do the same thing? I think this is very interesting. What do you think? Expectation-induced biases resulting from transcripts can also cause see, I'm reading my own words here. Can also cause insensitivity to the level of degradation in auditory statements, which in turn diminishes the ability to question one's own confidence in accuracy. That's huge, I think. Not even a court is immune to the curse of knowledge, these words, and will become unable to fairly review the truthfulness of a transcript. The curse of knowledge. I love these statements. A research team recently conducted a study to test the actual effect and impact of the transcripts on Ms. Smart's jury, and the creation of an expectation-induced bias was confirmed. Introvertibly, transcription is best suited for professional transcribers who lack prior knowledge of the case. Did I not say that? Independent third party. Professionals, these people that I've told you, I'm not going to rehash my story. I can stand that. Who lack prior knowledge of the case. So that's what I was saying. Whoever it was in the Attorney General's office, they're going to think of the words that they most often hear, potential, which could be crime biased. No safeguards to protect from bias were implemented for Ms. Smart. The science affirms prejudice already established by the court record. The record from the trial court makes clear that the jury heavily relied on the alleged content of the tapes, and without this consent, there is a reasonable probability that Miss Smart would have been acquitted. A juror recorded her thoughts at home on a tape recorder each evening of trial, and these tape recordings were later played onto and made part of the record. Wow. The juror was adamant that there was no way Miss Smart could be convicted without the body wire tapes. And during the trial, it was the transcripts that made the body wire tapes of any use to the jury, as much of the audio from the tapes was uninterpretable, whatever, and they call it unintelligible, that's the word, without aid from the transcripts. Regrettably, the juror was struck with the curse of knowledge, and heard what the juror was instructed to hear based on the heavily biased transcripts. The state provided inaccurate transcripts to the jury that created cognitive bias, causing the jury to hear incriminating statements that the audio did not reflect. Research demonstrates that the use of transcripts accompanying degraded audio produces a cognitive bias in which the listener is influenced to hear what the transcripts tell them they will hear. A recent study applied this principle to excerpts, there you go, from audio clips used in Ms. Smart's case. The study confirmed that participants who listened to the audio used in Ms. Smart's case were highly influenced by having an accompanying purporting to decipher the audio. In contrast, participants who listened to the audio but were not given any accompanying text rated the audio as less clear and rarely reported hearing the same words as the transcript. Eyebrows. These findings were consistent with a growing body of research confirming the prejudicial impact of inaccurate transcripts and highly suggest that the jury in Miss Smart's case was likewise biased by the state's transcript. Holy moly. I want to find, maybe we'll do a practical. Would you like that? Let me know. Would you like to test this out? Should we test this out for ourselves? What do you think? So interesting. And again, this can apply in so many cases. And again, I'm taking my example from just the case that I most recently pushed back on, where it was horribly wrong. It was horribly wrong. And I can't say they always, typically the transcripts are used. They're used for exhibits. So when motions and things gets filed, the judge motions pre-trial and during trial, the judge does not hear the audio or watch the body-worn camera typically. It is the transcript because it's paper. It's easier to attach electronically. So I'm wondering, holy cow, do we have Pandora's box here with inaccurate transcripts? And because I like AI, can AI help us in this to help? Like how much of a problem do we have here with convicted people where this could be a factor? Okay. All right. Very, very interesting. Once again, thank you for being here. We're going to continue with this. We've got all kinds of cases going on. I really appreciate the support. Thanks for liking and sharing. Let me know what you think about, I will try to find that audio, or if you really want to do this, let me know in the comments and we can do this and we'll see what happens. We can see what we hear and we'll see what AI hears. I've got a couple different AIs that can transcribe and we'll see if there's a good method to do it and we'll see what happens. So let me know. All right. I will see you on the next one.